before we have Mr. Chairman call the case, I wanted to mention a couple of things to the attorneys. Technology has been working very well. We haven't had any real problems, but if we do have something that crops up, we'll take a pause till we get it resolved, and we'll proceed from that. Everyone's cooperated very well and it's worked very well. Mr. Hibner and the IT personnel from the AOC have done a truly incredible job to make it work for even those of us who are not all that tech savvy. Mr. Hibner, would please call the case.
Elizabeth Kerr et al. Versus Lydia Henderson et al.
We'll hear from the appellant. You need to unmute. Unmute.
There we go. Can you hear me now, Your Honor?
Yes.
I apologize.
I've done it myself, and it happens. That's the one thing that happens often. I thought about just making a little sign that says unmute.
That might be a good idea. May it please the court, my name is Mark McFall, and of the Washington County Bar. I represent the appellants, Lydia Douglas Henderson, Scott Douglas, and Benjamin Douglas. They were the defendants below. The subject of this appeal is what began as approximately $1 million in tax-free Tennessee government bonds that were held by the plaintiff's father, Edwin Sturdivant, in his Raymond James investment account, beginning in approximately June of 2000, and bequeathed by his last will to his wife, Mary Sturdivant, who's the defendant's mother. The court must determine whether the denial of the defendant's motion to alter or amend judgment regarding the summary judgment granted to the plaintiffs, which ordered that these funds belong to the plaintiffs, was proper, or whether it should be remanded and reversed, and the court have further proceedings below. Your Honors, this is a case involving three daughters who all received their generous shares of their father's estate pursuant to his last will after his death in 2007, and who then proceeded to formulate a plan over the next 9 years to also receive their stepmother's estate, a plan to override their stepmother's will, their father's will, a plan to leave their step-siblings nothing. Edwin Sturdivant executed his last will on June 20, 2000, which he drafted without assistance of an attorney. In the last will, Mr. Sturdivant bequeathed to his wife, Mary, the defendant's mother, quote, 1,000 Tennessee bonds valued in total at face, paren, not market, close paren, value at $1 million, close quote. And that was if Mrs. Sturdivant survived him by 6 months, which she did. Edwin Sturdivant then died September 12, 2007. The plaintiffs allege in their complaint that Mr. Sturdivant, quote, added additional terms and instructions, end quote, to his last will with a typewritten letter dated March 5, 2004, and purportedly directed to his wife, Mary Sturdivant. This letter clearly did not qualify as either an amendment or a codicil to his last will. Nonetheless, the plaintiffs take the position that this letter forms the basis for an express trust of which Mary Sturdivant was the trustee. The plaintiffs are the beneficiaries and the government bonds are the trust race. The initial point of our argument, beginning at page 22 of our brief, is that the trial court erred in failing to consider the newly offered evidence contained with our motion to alter or amend judgment. From the commencement of this action on September 30, 2016, until a hearing on March 8, 2019, the defendants in this action were the co-executrixes of Mary Sturdivant's estate. At that hearing, the trial court substituted the current defendants, Mary Sturdivant's adult children, and the real parties in interest. Until that substitution, the defendants take the position that they were frozen out of any participation in the litigation and were prevented at every turn from providing or receiving any information. Their participation was, however, critical to the case. At the summary judgment hearing, the trial court granted plaintiff's motion for summary judgment and ordered the funds in Mrs. Sturdivant's individual Raymond James account, which originated with the government bonds in Mr. Sturdivant's account, be released and paid to the plaintiffs. Defendants then timely filed the motion to alter or amend that's the subject of this appeal regarding the granting of plaintiff's summary judgment motion. With our motion, we attached exhibits A through M as newly offered evidence. The court ultimately entered an order denying our motion on December 27, 2019. In that order, the trial court found that the newly offered evidence, quote, should not be considered. Trial court further found that, quote, the evidence submitted by defendants in support of their motion was not new evidence and was reasonably available prior to the time the summary judgment motions were argued. Defendants concede that much of the newly offered evidence was reasonably available prior to the time of the summary judgment motions. However, defendants submit that the failure to offer this evidence at the time of the summary judgment was due to the utter failure and refusal of defendants' then counsel to allow the current defendants to participate in the litigation and offer this evidence. This issue was raised at the hearing on the motion to alter or amend, and a colloquy occurred between the trial court and defense counsel on this issue. The trial court asked whether the alleged conduct of former defendants counsel was a basis for admitting new evidence or the newly offered evidence. Defendants counsel conceded there was no legal authority to that effect, but argued that the trial court, which is a chancery court, is a court of equity and should look at the equities of the parties and determine that there was a lack of fairness and inequity in how the summary judgment came about. Defendants also concede that the general rule of law is that in civil cases, relief may not be premised upon ineffective assistance of counsel. And we cite the Thornburg v. Thornburg case for that proposition. However, the Thornburg court recognized that there may be cases where the facts are so egregious that justice may require some relief. The court's words. Defendants submit that the record reflects this is such a case and justice requires some relief. The affidavit of Lydia Henderson, filed with the defendant's motion to alter or amend, details the problems that defendants were having with then defense counsel George Wright. Had Attorney Wright cooperated with Mary Sturdivant's adult children and with the attorney engaged by them to assist them with that process, when they tried to enlist Mr. Wright's cooperation, from the commencement of the action until the summary judgment, the newly offered evidence could have been part of the defendant's summary judgment case. We additionally argue that the defendants, the trial court failed to properly apply the five-pronged analysis set forth in Harris versus Churn and its progeny for considering newly offered evidence. In neither the order denying the defendant's motion to alter or amend, nor the verbatim transcript of the trial court's opinion that is attached to and made part of that order, does the trial court follow the five-pronged Harris analysis in rejecting the defendant's newly offered evidence. The trial court said at the hearing on the motion to alter or amend, quote, The cases say you can't just put out a little bit of your evidence and hope it defeats a summary judgment. That is not what happened in this case, however. As shown by defendants' newly offered evidence, these defendants tried to get the previous defendant's attorney to listen to them and look at the evidence they had to offer. If that had occurred, the newly offered evidence could have been presented at the appropriate time and properly considered at summary judgment.
Well, counsel, I mean, they were free to fire him, weren't they?
They weren't free to fire him until they were substituted in as the actual defendants in the case.
And when did that happen in the process?
That happened. Well, that happened at the hearing on March 8th, 2019.
That was the hearing on what?
Well, that was, I think ostensibly that was supposed to have been a hearing on the summary judgments, the respective summary judgments, but it actually became sort of a housekeeping matter, and the court took care of several procedural issues and then granted an outstanding motion to substitute my clients as the appropriate real parties in interest in the case. But it did occur before the July 2019 summary judgment hearing. And I believe I'm out of time, Your Honor.
You are. You have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Thank you, and may it please the court. My name is John Graham, and I represent the appellees Elizabeth Kerr, Victoria McCoy, and Angela Sturdivant in this matter. The first point I'd like to make is that this appeal has been narrowly tailored by the appellants as being a challenge of the trial court's denial of their Rule 5904 motion to alter or amend judgment. This challenge carries with it an abuse of discretion standard, meaning that the appellant must show that the trial court applied an incorrect legal standard, came to an illogical or unreasonable decision, or reached that decision by relying on a clearly erroneous assessment of the evidence. In addition, that heightened standard is to be applied to a motion to alter or amend, which itself is generally disfavored by Tennessee courts and has been characterized as an extraordinary remedy that should be granted sparingly. A Rule 5904 motion should be granted only when controlling law changes before a judgment becomes final, when previously unavailable evidence becomes available, or to correct a clear error of law or to prevent injustice. The trial court reviewed the materials provided by the appellants and correctly ruled that the appellant's motion falls short of this high bar and certainly did not abuse its discretion in making that ruling. While it wasn't raised by the appellants, I'd also like to make the point that even if this appeal is somehow construed to include a summary judgment challenge, Tennessee courts have previously held that where a trial court provides more than one basis for the ruling, an appellant must appeal all the alternative grounds for that ruling. The appellants did not challenge the trial court's alternative holding of a constructive trust, and so have waived any claim of error as to the ruling. As Mr. McFall provided, one of the primary issues raised within the appellant's brief is that the trial court abused its discretion by failing to consider their late filed evidence. Mary's children strained to justify their attempts to submit roughly 90 pages of evidence, which they really only mustered after summary judgment had been granted. In applying the Harris factors, for three of these factors, that is, effort of movement to acquire the evidence, explanation of the movement for not providing the evidence in its initial response, and the any other relevant factor, the appellants only offer the excuse that they made the attempt to bring the evidence to the court's attention, but that those efforts were stymied by the attorney for the original defendants. In response, I believe that there are three dates that the court should be made aware of. The first is November 8th, 2017. This is the date in which the appellants hired their first attorney, Mr. Olin Bailey. They hired him over 1 year before the motion for summary judgment was filed and 16 months before the discovery deadline. By the appellant's own admission, Mr. Bailey was in communication with Mr. Wright, who was the attorney for the original defendants. He discussed strategy with Mr. Wright, and he offered assistance to Mr. Wright. So despite having an attorney who was involved in the case, the appellants did not attempt to intercede on the case. The second date that I believe the court should be made aware of is February 14th, 2019. This is the date in which Mr. Wright filed affidavits of Lydia Henderson and Sylvia Pennington. And I believe that this shows that there was not a complete shutout of the appellants by Mr. Wright as they attempt to claim. But the third and most important date is March 8th, 2019. The appellants were substituted as parties in the lawsuit on that date, and they were represented by the counsel of their choosing. And during that 4-month period in which they were represented parties, they did not serve discovery. They did not seek an extension of the discovery period. They did not ask the court to allow supplemental summary judgment materials, and they did not request that the court allow them time to provide any supplemental briefing. They took no steps to submit any of the evidence that they're now presenting. This was even noted by the trial court at the Rule 5904 motion hearing in regards stating that at the summary judgment motion hearing that it rolled out the red carpet for anyone to submit any additional evidence and that everyone appeared ready to proceed on that day. In addition to that, Mr. McFall points out that he admits that ineffective assistance of counsel is generally not ineffective assistance of counsel is generally not a good enough reason in a civil matter, and points to Thornburg v. Thornburg as an exception, as an example of that. In Thornburg, I believe that in Thornburg v. Thornburg, the wife's attorney did not follow any discovery procedures, failed to notify opposing counsel of the witnesses she attended a call, which resulted in their testimony being excluded, and failed to make an offer of proof as to the excluded testimony. This is the same, if not less egregious than the example given in Thornburg v. Thornburg, in which the court held that this was not a case that was egregious enough to justify a theory of ineffective counsel. The fourth Harris factor that also favors the appellees is that the evidence must be important. Importance has been interpreted as meaning that if the evidence was to be admitted, that it would likely result in a different outcome of a new trial. The appellants don't even attempt to make this argument. They argue only that the new evidence would give a more objective picture of the parties, and they recklessly maintain that the forensic report casts doubt on letters from married to the appellees. We believe this is just a transparent attempt to cast Ed and his daughters in a negative light, and the appellants really make no serious effort to argue that this evidence would alter the outcome. And the trial court agreed, finding that not only was it not likely to result in a reversal, but that much of the evidence presented by the appellants supports the appellee's position. The affidavit for Mary's original estate planning attorney stated that in Mary's original will, the account that is the corpus of the trust was left to Ed's daughters. This reflects our understanding of the timeline and our understanding of Mary's intent. The Drexler report also states that it's a strong probability that the cover letters to the TOD forms were typed on Mary's typewriter. And it states that within the Drexler report, the strong probability is equivalent to a virtual certainty. Also, Mary's children accuse the trial court of failing to follow the Harris analysis, but the transcripts of the court's oral ruling shows that the court seriously considered the factors and found the appellant's argument lacking. Now, it's true that the court didn't specifically mention each factor in turn, but I can't find any authority stating that that's a requirement, and the appellants have provided no such authority. The appellant's arguments simply don't pass muster under the Harris factors. They did not attempt to gather this evidence until after the appellees were granted summary judgment, and they shouldn't be granted a second bite of the apple now. The second large portion of the appellant's brief is the claim that the trial court abused its discretion by failing to reconsider its reliance on several authorities that the trial court discussed while orally pronouncing summary judgment in the plaintiff's favor. The appellants point out several cases that were relied upon by the court, and they make broad claims about how the facts are different, but the appellants don't explain how these differences erase the existence of an express trust. They don't explain what the elements of an express trust are, and they don't explain how the undisputed facts of this case don't fit those elements. And they don't cite any authority to that effect. Appellants also, in making these arguments, violate the tenet that was expressed in Morrison v. Morrison, that a Rule 5904 motion should not be used to simply relitigate a matter that's already been adjudicated. They ignore that the function of this motion is not to renew arguments that the court has already considered and rejected. This matter has already been decided by the lower court, and it's been decided not once, but twice now. And as stated previously, this is an abuse of discretion standard, meaning that this court's not being asked to substitute its judgment for the trial court's, and it need not relitigate this matter for a third time. Also, in this section of their briefs, the appellants raised several new arguments relying on their late filed evidence. Again, this is not the purpose of a Rule 5904 motion. I would point out to Leggins v. LaCourneau. In that case, the plaintiff's arguments within a Rule 5904 motion were denied because the plaintiff was attempting to use evidence that did not pass the Harris factors to make legal arguments. And the court determined correctly that the Rule 5904, that was not the function of a Rule 5904 motion. The final argument presented by the appellants within their brief is that the trial court abused its discretion in failing to revisit their affirmative defenses of res judicata and collateral estoppel. Again, this argument is not appropriate for Rule 5904 motion. It's simply an attempt to relitigate a matter that's already been adjudicated. The trial court clarified its denial of the appellant's defenses at the motion to alter or amend hearing, and determined that the probate of Ed's estate involved different issues than the ones that are raised here, so that neither res judicata or collateral estoppel should be applied. Res judicata requires the asserting party show that the parties were the same and that the same claim or cause of action was asserted in both suits. The appellants simply can't do that here. First, because Tennessee courts have held that probate proceeding is not an adjudication in the sense necessary to raise these defenses against this case. A probate proceeding is not an action between parties, but it's an opportunity for those parties to contest the validity of the will offered. That's not what the appellees are attempting to do here. Our claims surround the acts and writings of Edwin and Mary outside of Edwin's probate process. Secondly, Tennessee courts have been clear that a prior judgment or decree does not prohibit the later consideration of rights when the facts have changed or when new facts have occurred which alter the party's legal rights. And a primary element of the appellee's claims are the writings and actions of Mary, which took place after the estate of Edwin Sturdivant's probate proceedings had been completed. It's for these same reasons that the defense of collateral estoppel is unavailable to the appellants, because Mary's children can't show that the issue to be precluded was decided in an earlier proceeding. They can't show that the issue to be precluded was actually raised, litigated, or decided on the merits. And they cannot show that Ed's daughters had a full and fair opportunity in the earlier proceeding to contest the issue. Also, if the appellant's argument regarding collateral estoppel or res judicata were true, the outcome of Brunson would be illogical. That case also involved a challenge that was made after the estate of the decedent was closed. And just like that one, these claims run outside of Edwin's estate proceedings. This claim deals with writings of Edwin and Mary which occurred outside the probate of Edwin's will. So these affirmative defenses simply don't apply. So essentially, to finalize my argument, the appellants did not act diligently in presenting evidence to the opposition of the appellee's summary judgment motion, despite having their own attorney and despite being substituted as real parties in interest 4 months beforehand. They waited until after the judgment had been entered to begin gathering evidence in earnest. The evidence that they now present is late, It's not likely to result in a different, or to end in a different result, and it largely supports the appellee's presentation of the facts. The remainder of their appeal is simply an attempt to relitigate the summary judgment motion, which is not an acceptable use of a Rule 5904 motion. And even if it was, the trial court didn't abuse its discretion in making those rulings. The trial court was correct to deny the appellant's Rule 5904 motion, and the appellees would request that this court affirm the denial of the appellant's Rule 5904 motion. Thank you.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you, Judge Sweeney. The one thing I want to touch on that Mr. Graham touched on but really didn't discuss in much detail are the transfer on death forms. These forms become very important in this case. There's an allegation that Mary Sturdivant had sent transfer on death forms for Raymond James to her stepdaughters to fill those forms out so that they would have this fund or the bonds transferred to them on Mary's death. And as has been clear throughout the case, there's no evidence that Raymond James ever received these forms. There's no evidence that the plaintiffs ever mailed the forms. And just because she sent those TOD forms to her stepchildren didn't prevent her from redoing her will, which she did. And we explain in our brief, and that's part of the summary, additionally offered evidence, newly offered evidence, what precipitated the change of Mary's will. She became very upset with Mrs. Kerr, and she changed the will, which she had a right to do.
So did she name the Raymond James fund in her will?
The Raymond James fund was not specifically named in her last will and testament. And as the testimony or the affidavit of her longtime attorney in Johnson County stated, she did do a prior will. We laid it out that she had the prior will and it gave those funds to the stepdaughters. But unfortunately, Ms. Russell does not maintain copies of old wills, and we don't have that will to see what exactly it did say. But no, Your Honor, she did not have that in the will.
Okay. Thank you.
The other important point is how her Raymond James account was set up. During or toward the end of the administration of her husband's probate estate, the attorney that was representing Mary and Mrs. Kerr as co-executors of that estate arranged for Mary to set up her own individual Raymond James account. Now, there was an opportunity there for Ms. Kerr to interject as co-executor and say this should be an account, a trust account, not an individual account. These funds need to go into a trust account. That was never mentioned. It was never raised. These funds were put in Mary's individual Raymond James account, commingled with her own personal funds. And that, I think, is extremely strong evidence of what she intended those funds to be. And they should have gone through her last will to her children, not the other way. Thank you very much for considering this, Your Honors, and I appreciate the opportunity to be here today.
Sure.
Thanks to counsel for both sides for your oral arguments and your briefs. I think you certainly made the issues clear and your positions on them. Mr. Hivner, if you would, please adjourn court till our next regularly scheduled docket in August.
This honorable court is now adjourned.